No, in item number 14, we have filed two activities. One activity, one activity reply.
Item number
14.
14.
Yes. Yesterday we have filed the two activities. Document and activity, madam. So I will reduce document.
Isn't it infructuous?
No, not better. Garden is still lying closed. They have not taken any action. Garden is still closed. So closed. Workers, a few workers, my lord, who are they are entering that green leaf there. And administration is not taking any action, my lord.
Okay, so you have filed reply affidavit,
Reply as well as additional affidavit along with the
additional. So two affidavit.
Yeah.
Yesterday you filed it. Yes. So when do you want?
Next week, next time.
Yes. When? Okay, right. Mr. G.N. Sahawala, learned counsel for the petitioner, submits the additional affidavit and reply affidavit has been filed yesterday.
Yes.
Accordingly, this is not after review.
My lord.
No, give a date. Handle this matter after review.
Item number 11, my lord. By oversight, my lord, steps for one respondent was not taken, my lord. So we'll take during course of the day itself, my lord. What do you want it then?
What was not done?
The steps upon respondent number 8.
There is no respondent number 8.
There is, my lord, we have taken steps up to respondent number 7. One person has been left out. Or respondent number 7, my lord.
There is
We
no
have We have taken to the government.
there is no respondent number 8.
Yes, yes.
Then
So we'll take the steps.
well, where's the question of fresh steps when there is no respondent number 8?
No, my lord, from the office, no, publish it reveals, my lord, we have not taken steps.
No, because it was a mistake committed by this court that notice should be taken, a step should be taken on respondent number 8, but there is no respondent number 8.
But otherwise, we have taken steps all of the government.
So what is the service? Government is here.
They have taken steps.
Then okay. Right.
Eight to
There, there is a error in the last order wherein this court had directed that steps should be taken for service of notice upon the respondent number. However, there is no respondent number 8 in the writ petition. As such, the order directing the petitioner to take steps for service of notice upon the respondent number 8 as per the last order is hereby recalled. Full stop. Mr. G. Bokalial appearing for the response number 1 to 7 submits that affidavit has been sent for vetting and the same will be filed within 3 weeks. List the matter after 3 weeks.
May it please the Lord. With the consent of other side, Lordship, I beg to mention item number 23. Here I required some time to file my affidavit. Item number 20.
Show me. Yes, okay. What is your case now? You have submitted a false document. They are rejected.
Now third party right has also been filed.
No, Mr. Counsel, let me ask you one. When the IOCL has stated that the document you submitted is a forged document, what remains? What instruction will you complete? Huh? Okay, we'll give you time. Because once they have said that they have not issued the document, that means that you have forged it. Okay, right, Mr. N. Gautam, learned counsel for the petitioner, submit that he will obtain instructions as to, and with regard to the communication sent by the IOCL to the effect that the document submitted by the petitioner had not been issued by the IOC. As the above stand taken by the IOCL gives rise to an inference that the petitioner has committed a fraud, comma. The petitioner would have to answer the question as to why the writ petition should not be dismissed for playing a fraud on the respondents. Full stop. Next para. Mr. S.S. Roy, the learned counsel for respondent. The HPCL submits that the tender has been already awarded to whom? To the successful tenderer. And as to the next highest bidder, to the next highest bidder. And as such, the writ petition should be dismissed as third party rights have been arisen. However, the petitioner has not made any application for impediment of the successful bid. List the matter after, after 2 weeks. There is no stay, so it doesn't matter.
Next is a lot. Not LGR item number 25 lot. That I have instruction to withdraw with reverting lot.
Item 25. It is that MSC matter, that's point number 8.
Yes.
Oh, he's happy.
We may come with some better thing.
Yes, yes. Problem. Yes, okay, right. Mr. R. Dubey, learned counsel for the petitioner, submits that he has been given instructions to withdraw the writ petition with liberty to file.
With it.
He accordingly prays for the same. Mr. S.S. Roy appears for
Respondent number 6.
response number 6, while Mr. K. Gogoi appears for
1 to 5.
1 to 5. Mr. S. Bhattacharya appears for response number 8. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as well. Huh? There's no, interim order passed earlier stands vacated.
Please, your option. That is for listing of offer matter. Friday month. Friday patterns to settlement of the market.
Settlement of the market. Why not tomorrow? Huh? Tomorrow? Friday will be slightly because our new chief will be arriving. And there'll be a reference also on Friday.
Tomorrow.
Tomorrow also there is another reference, but still tomorrow there's no space, breathing space.
Okay.
When
orders on
go to the registry matter. Pending matters, go to the registry. New matters, you can come in.
saying part of this matter for the time being and we heard along item number 20. As both the matters are allowed.
Okay, no problem. Mr. H. Gupta, you are there. You are for whom? Oh, you are for the river. Okay, right. Third, Mr. B. U. Laskar, learned counsel for the petitioner, to submit that the petitioner's vehicle hire charges amounting to rupees 82,63,380 has not been paid. Issue notice returnable in 4 weeks. Mr. G. Bokalial accept notice on behalf of all the respondents. This is the matter of the court. To enable the respondents to file the affidavit. Mr. S.N. Adhyapak appears for the petition and submits that though the work has been completed, the contractual dues of the petition has not been paid. Issue notice returnable in 4 weeks. Mr. G. Bokhalia accepts notice on behalf of
1, 3, 5 and 6.
1, 3, 5, and 6. What about the others?
Notice to prove.
No, finance, which finance?
Finance is there.
Mr. B. Oy or R.M. Barwa, who? What about so Mr. B. Oy accepts notice on behalf of respondent number 2 and 4.
2 and 4.
Petitioner takes steps for service of notice upon the respondents number 7 and 8 by registered post with AD within 2 days. Leaves the matter of the whole. Item 4 same. Same one. Acha, Mr. Chalia is there. Is there a Mr. B. Gogoi put Mr. A. Chalia? Item 5.
Oh my God, it can start with a lot with the A of party. Date of birth is not a party, but the commissioner is right in the party. Page number 4, my lord. Yes. Okay, the
Yes.
commissioner is the- And GNC also not a party, only the, just a party, next part. GNC, the state, GNC, the state, and article the
State is not a party. Make a party. You withdraw with deputy or what? You going to file amendment petition or what?
It is more difficult, my lord, showing the picture.
If you withdraw, because if you make amendment, you have to file amendment, then you're going to file amended.
Post title and.
Huh? Mr. Shaitan learned counsel for the petition feels that he may be allowed to withdraw the petition with the ability to file a fix. Mr. S. Bora appears for the requirement number
1, 2, 3, 1, 2, and 3.
the petition's counsel prayers allowed. This petition is dismissed as withdrawn with liberty as speech.
This is.
Huh? D voter matter. Your name is? N. Uddin. Learned counsel for the petitioner. You are Mr.
H. Kudi, appearing on behalf of the AIL. For election.
H. Kuli. Kulli.
Yes.
Appearing on behalf of Mr. A.I. Ali, learned counsel for the respondent number
Respondent number 3.
3. And Miss S. S. Dole. Four, 2, and 6. What about 1, 4, and 5? So who is appearing for Union of India? Who? K. Gogoi for respondent number 1. And what about 4? G. Bokalian for respondent number 2, 5, and 7. Okay, you are D voter for which year? 1997? And what is your 39 number? Jaleshwar LAC, village 122 Folimari. That's all. Nothing. What is your name? Your name? Huh? S.I. Talukdar. S.I. Talukdar for the petitioner. Then Mr.
H Puri,
H. Puri appearing for Mr. A.I. Ali for
Respondent number 4 and 5.
this point number 4 and 5. Miss S. Dole appearing for Mr. J. Payeng for this point number 2, 4 and 6. For 4 and 6. That 2 and 6, 2 and 6. Mr. G. Bokalel appears for 5 and 7. Okay, you are in the voters list.
97, case,
Which voters list?
97,
97
case number 40.
and 2024 also.
Yes, Lord.
Page number 40,
40 and
40 and 42,
43.
43.
44. 11.
I cannot read 43, it's in assembly.
42, Lord.
Huh?
40.
40. So it is with regard to what, which area? It is with regard to your D786. Correct? In respect of what? 56 number,
Yes, Lord.
56 number, Rupahi Hut,
Yes, Lord.
LAC, na? Part number
70.
70, yeah, 76.
In 97, sir, Lordship, 70. Seventy, 2024.
Huh?
24 is
No, no,
76.
in 1997,
Yes, Lord.
what was the number? D786? In
Yes, Lord.
1997, D786, is it?
My serial number 647, part number 70.
Yes, serial number in 1997, the petitioner serial number in 1997 was
647.
647. In respect to 56 number Rupaya Hut, is it?
Yes, Lord. 85.
How can it be changed? So 85 number Rupaya Hut,
Yes, Lord.
LAC. Part number
70.
70. Full stop. In the 2024 voters list, the petitioner
Serial number is
was, petition serial number was
786.
D786. D786 in the voters, in respect to 56 number.
76.
In respect to 76 number. No. Huh?
58. 58.
58. In respect to 58 number, Rupahi Hut LAC. Part number
70.
Part number 76. Okay. So that part will have to be changed. Huh? Okay.
The potential not refund of unless money laundering. The petitioner person to tender notice action submitted the petitioner society submitted the application.
Yes. Huh?
We'll take instruction like.
What instruction? Dispose of the representation.
No.
He is the unsuccessful bidder.
Yes.
Correct. Then
Similarly, the society had approached the committee court and the order was passed.
okay. Okay, right. Heard Miss P. Sharma, learned counsel for the petitioner, who submits that the petitioner had participated in the notice inviting tender dated 28/01/2021 for settlement of number 25 Deepul Jijan, number 28 Garanga, number 103 Garsak, number 104 Malya Group Fishery. That is in the synopsis. However, the petitioner was unsuccessful in the tender process and as such was not selected. And as such, the petitioner's bid was not selected by the respondent authority. Though the fishery has been settled with the successful bidder, comma, the earnest money of the petitioner, earnest money only or what?
And
The earnest money of the petitioner has not been returned to the petitioner till. He further submits that though the petitioner has submitted a representation dated 5/6/2025 to the District Commissioner Morigaon Guwahati for return of the earnest money, the same has not been returned to the petitioner till. Next paragraph. The petitioner's counsel submit that in a similar matter, comma, this court, provide order dated 28/8/24 passed in WPC 4236 of 2024. Had directed the Deputy Commissioner had directed the concerned Deputy Commissioner to take a decision on the petitioner's representation for return of the earnest fund within a period of 10 days. He submits that a similar order may be passed in the present case. Mr. G. Bokalia appearing for all the respondents submits that they have got no objection to the prayer made by the petitioner. This paragraph. In view of the petitioner's submission that the earnest money has not been returned to the petitioner, despite the fishery having been settled with some other person, with some other tenderer. This court is of the view that the order dated 28/8/2024 passed in WPC 4236 of 2024 is applicable to the present case also. Accordingly, the Deputy Commissioner Morigaon, District Commissioner Morigaon, is directed to take a decision on the petitioner's representation dated 5/6/2025 for return of the earnest money within a period of 10 days from the date of receipt of a copy of this order. The petition is accordingly disposed of.
Right.
26.
Can we get in settlement of biweekly market?
Huh?
Settlement of market. So, although the date was fixed on 25/6/2025, the Honorable Court directed to extend the date till 22/7/2025. But on 25/6/25, the bid box was open, Lordship, and my bid was also open. So, Lordship, my bid amount is known to the document authority and give the sound to PTO.
So you submit a fresh bid. You submit a fresh bid. We'll allow you to submit a fresh bid if it has been opened. Otherwise, what can be done? If it has been opened, now what has been done? That means it should not go to anybody or what? If you want to make a fresh bid, you make a fresh bid. Otherwise, what is the solution? You tell me. What can be the solution?
Otherwise, he cannot reserve his rate.
Correct. You cannot reserve your rate. You cannot say that I have to be given because it has been opened. We'll allow you to submit a fresh bid. That's the only solution. So you will give you an option to either stay with the allegedly open bid, we do not know, or allow you to submit a fresh bid because the last date is 22/7. It is not.
As per his document, last page, my last signature,
Ah.
it will be open on my lord, 22nd July.
Correct. That is why he can submit a fresh bid. Okay, right. Heard, Mr.
Yes, sir.
S.
Alam.
Alam, learned counsel for the petition, who submits that the petitioner had submitted his bid in pursuance to the NIT dated 7/6/2025. for settlement of the Santijan bi-weekly market. No, no. No. The petitioners, bi-weekly market, full stop. Wherein the last date for submission of bid was 25/6/2025. Full stop. However, as the NIT dated 7/6/2025 was put to challenge by one Ikramul Hussain, IKRAMUL Hussain, in WPC 3518 of 2025. On the ground that on the ground that not enough time had been given for tenderers to submit their bids, this court, by order dated 24/6/2025, passed in WPC 3518/2025, directed the authorities to allow the bidders to submit their bids in pursuant to submit their bids till 22/7/2025. Next paragraph. The petitioners council submit that in terms of the order dated 24/6/2025, passed in WPC 3518 of 2020, the last date of submission of bids has been extended. No, in pursuance to, in relation to the NIT dated 7/6/2025 has been extended till 2 p.m. on 22/7/2025. However, the petitioner's bid had been inadvertently opened on 25/6/25 by the respondent, by the state respondent, thereby enabling all the other bidders to know the bid amount submitted by the petitioner. He accordingly submits that a fresh bid, a fresh NIT should be issued. He submits that either the fresh NIT should be issued by the respondent or the petitioner should be allowed to submit a fresh bid amount, as the last date of submission of bids has not expired. In terms of the communication dated 25/6/2025 issued by the respondent number. Next, Mr. L. Datta appearing for the all respondents submit that he has got no objection to the prayer of the petitioner regarding submission of a fresh bid in pursuant to the NIT dated 7/6/2025. Come in as much as the last date for submission of bid is till 2 p.m. on 22/7/2022. Next one. The petitioner's counsel submits that he has got no objection. No, that's it now. Review the consent of the parties.
If not open, definitely.
Yes, sir. Review the consent of the parties, comma. The petitioner is allowed to submit a fresh bid pursuant to the NIT dated 7/6/2025 for settlement of the Santijan bi-weekly market. However, the same is subject to the condition that the petitioner's bid for the said market pursuant to the NIT dated 7/6/2025 has been opened by the state. State government. It's a question of fact, then you go to civil court.
Obviously deny because it will amount to the contempt of court. So here is the order of 24/6/2025. So obviously they deny. They did not.
Anyway, you have not opened others, so let him, let the condition be go. Okay, cut the condition.
I love it.
The writ petitions accordingly disposed of. Huh? Not allotted.
Yes.
Mr.
Yes, sir, I'm.
H.R. Ahmed, land counsel for the petitioner submits that the petitioner was the successful bidder in pursuant to the NIT dated 24/1/2025 issued by the respondent number 4. For the work, inward commas, construction of RCC drain with cover slab from JP Road near commercial building of Dilip Saha towards construction BJP office building. See, in the section of invert commas, okay? Though the petitioner, though the petitioner's bid value is found to be valid and is the lowest, no work order has been issued to the petitioner till date. Mr. G. Bokalial, appearing for
Response number 1 to 3.
response number 1 to 3. Shall obtain instruction with regard to why, who is to allot the work?
Why not 4? Response number 4.
Who is for 4?
Response number 5. They have to look at the tender.
So the issue notice,
No, so this one.
right, issue notice returnable in 4 weeks. Mr. G. Bokalial notice from the respondent 1 to 3. Petitioner takes care for service of notice upon the respondent number 4, 5, and 6. By which report to the division 2 days. This is the matter after 4 weeks.
Then this will not be barred.
Wait now. Let us see. Sir, A. Boro, land counsel for the petition. Praise that Mr. Akash Deep, IAS Principal Secretary, Bodoland Territorial Council, Kokraja, 783370 may be implemented as respondent number 2. As the earlier Principal Secretary has been transferred out. The prayer of the applicant's council is allowed. So and so is implemented as respondent number 2. But the applicant will submit a corrected copy of the corrected cost item to the registry within 3 days. Next. In the contempt, you write, in view of the order dated 16/7/2025. Passed in IAC number 2115 of 2025. The Akash insurance is implemented as the point number. Issue notice to the newly implemented as point number 2. Applicant to take, the petitioner takes step for service of notice upon the point number 2 by the court within 3 days. This is the matter of the phone.
Please, Your Lordship. Lordship, we are challenging the award passed by the Labour Court, wherein the respondent number 3, the electrician, he was reinstated with 50% back wages. Lordship, fact in brief is that this is a case of absence without leave. The electrician, he was absent for 50 days, admittedly, and without any authorized leave. When he came back, the petitioner, which is an industry, was not inclined to take him back. Since he's an electrician, it is an important job, and for 50 days he was not there. So the petitioner was not inclined. Accordingly, he filed a application under 33 2C before the Labour Court. The Labour Court reinstated it with back wages.
So what is wrong?
So, Lordship, the problem with the award, Lordship, is that the industry runs on the basis of an approved standing order. The entire award has overlooked that aspect. There is not even a single discussion as regards standing orders. The standing orders very categorically says that if any employee goes off the radar for more than 10 days without leave, that is considered to be voluntary abandonment of service. So there is no particular act that the employer has to do. It is a voluntary abandonment of service on the part of the employee
Or is it for 10 days?
for 10 days. So Lordship,
And he was out for
50 days. 1 month, 20 days. Admitted full.
how much?
1 month, 20 days. The entire award fails to even discuss that aspect. Lordship. And most of the
Where is that guideline?
standing order, page 38, Lord. Page 38. Point number 11, Lord. Page 38. 11 says absent without leave, abandonment of job, gain loss. So may I read the relevant one? A says if a workman remains absent beyond the period of leave originally granted or subsequently extended, he will lose his VN on his employment and his name shall be removed from the muster roll of the establishment without any notice unless he returns within 10 days. Lordship may also take note, page number 39, that is P. Point number P. A workman remaining absent without leave for a period of 10 days or more at a stretch shall be deemed to have abandoned the services and his name would be struck off without any notice or pay or compensation from the muster roll of the establishment. And F, Lordship. If it will not be necessary to seek permission from the appropriate government before striking off the name of the workman from muster roll on his being continuously absent for 10 days or more, as it will not be retrenchment made by employer on their part on his being surplus in the employment, but it will be a termination of service by the concerned workman himself. So these aspects, Lordship, are not even discussed in the order. Lordship will kindly take note of page number 113, the operative part of the award, page number 113 and 14. 113, paragraph 27. The Learned Labour Court goes on to observe that the settled principle of law is that whenever any authority wants to discharge, dismiss, or terminate any workman, which otherwise was not the case as per the standing orders, from the service, the authority must comply with the principle of natural justice. Principle of natural justice means fair hearing, in other words, opportunity to defend himself. Before kicking out any employee, the authority concerned must give him notice as well as hearing. In the instant case, petitioner was a permanent employee under management. He came back to join his office after leave or absence. However, he was not allowed to join in his service. PW1 admitted the fact that chauffeur's notice was not served upon him. He also admitted that except salary, nothing was paid to him. 28, from the scrutiny of the evidence on record and also admission of management, that it appears that management has not given an opportunity to the worker to defend himself. Even chauffeur's notice was not given to him, and thereby management has totally violated the principle of natural justice. In such circumstances, management is not justified in not allowing the workman Shri Janish Lal Ray after return of leave absence to continue him in service without following the procedure of law, and as such, he is entitled for it. So, Lordship, contrary to what is dictated as per, so Lordship, I know
No, but then that, the guidelines, it's a guideline or what? Is it a guideline that you were reading, page 38, 39?
page 38, 39, Lordship, this is a standing order. So,
Standing
I-
order.
means-
So this standing order does not indicate anywhere that notice did not be given.
Yes, nowhere,
Then-
nowhere, Lord. So,
then-
far as this is concerned,
Then-
notice need not be given. It is a voluntary abandonment of service. And in fact, Supreme Court.
No, no. Whether we say that notice did not be given.
Lordship may take note. Well, come to that relevant portion, wherein it specifically says that
You come to that portion only, that is the only issue. There's nothing else.
Lordship, 11A,
11,
11, same, 38. The one that I had read, 11A, page 38.
yes,
If a workman remains absent beyond the period of leave originally granted or subsequently extended, he will lose his lien on his employment and his name shall be removed from the muster roll of the establishment without any repercussion, unless he returns within 10 days. I will also rely on a few judgments by the Honorable Apex Court 2013 onwards, wherein in similarly situated
repeat the, yes,
Lordship, first I'll refer to Bharatiya Kamgar Karamchari Mahasangh versus Jet Airways Limited. This is 2023, judgment of 2023 by the Honorable Court. Lordship, may kindly refer to paragraph 7.
yes.
Paragraph 7, which is page 4 of the judgment. On various occasions, this court has observed that the certified standing orders have a statutory force. The standing order implies a contract between the employer and the workman. Therefore, the employer and workman cannot enter into a contract overriding the statutory contract embodied in the certified standing. Lordship, may come to next page, paragraph 9. Third paragraph, Lordship, the intendment underlying the act. The intendment underlying the act and the provisions of the act enacted to give effect to the intendment and the scheme of the act leave no room for doubt that the standing orders certified under 1946 Act become part of the statutory terms and conditions of service between the employer and his employee, and they govern the relationship between the parties. 10, the court also re-emphasizes the terms of employment specified in the standing order would prevail over the corresponding terms in the contract of service and existence on the enforcement of the standing order. Lordship, the court goes on to say
Now,
that.
just tell me one thing.
Lordship,
What do you mean by certified standing order?
Lordship, the Industrial Dispute Standing Order Act.
No, no. Now the document that you're relying upon,
Yes.
the guidelines you're relying upon.
Yeah.
Or the standing order, is it a certified standing order? What is the difference between a standing order per se and a certified standing order?
So, Lordship, a certified standing order is certified by the certifying officer as per the Industrial Employment Standing Order Act of 1946. Otherwise, this draft is sent to that certifying officer who then,
So where do you get all that?
Lordship,
From where do you get that? That it has to be certified by that particular officer?
Lordship, Section 5 of Industrial Employment Standing Order.
Where is that? Section 5.
Lordship has Industrial Employment Standing Order by 1946. I have a different copy. May I send it?
Yes, yes.
I will also be relying on Section 12 of the said Act, which very specifically also.
So this standing order that we have relying upon,
Yes, Lordship.
this is a certified standing order.
Certified standing order having statutory force, and while the labor court was adjudicating the matter, the labor court did not even address the fact that the industry is running on the basis of a certified standing order. In fact, it is mandatory that the industry has to run on the standing order. So this was not even adjudicated anywhere in the entire award. And we had raised that plea in the course of trial.
So this is certifying standing orders are made in exercise of the Industrial Employment Act, 1946,
Industrial Employment Standing Orders Act 1946, that's the section 5.
as per section 5. Correct.
Lordship. I have more judgments, Lordship. Lordship, may
No,
kindly.
no, wait, you have got only to one judgment.
Yes.
Then what is the next?
The next judgment specifically deals with the matter in hand, Vijay S. Satai versus Indian Airlines, 2013 by the Supreme Court. Lordship, may kindly refer to page, paragraph 9,
Yes,
page 3. The last part, absence from duty in the beginning may be a misconduct, but when absence is for a very long period, it may amount to voluntary abandonment of service. And in that eventuality, the bonds of service come to an end automatically without it requiring any order to be passed by the employer. This is what has happened in our. Lordship may kindly refer to paragraph 11.
yes.
For the purpose of termination, there has to be positive action on the part of the employer. Effective time. 5. Only 5 and 12 also. I will. 11 says for the purpose of termination, there has to be a positive action on the part of the employer, while abandonment of service is a consequence of unilateral action on the behalf of the employee and the employer has no role in it. Such an act cannot be termed as retrenchment from service. Paragraph 13, Lordship. In Syndicate Bank, a lot of judgments were referred. If a person is absent beyond the prescribed period for which leave of any kind can be granted, should be treated to have resigned and ceases to be in service. In such a case, there is no need to hold an inquiry or to give any notice, as it would amount to useless formalities. A similar view has been reiterated in Swens of 2-3 judgments. So, Lordship, law is also otherwise.
What happened? Did he come back?
He came back after 50 days. In fact, if your Lordship will also see one more aspect, even he was not praying for reinstatement. Even he was not praying for reinstatement. He just wanted some money, whatever that is due to him. Lordship may kindly refer to page 55. Page 55, Lordship. There. 55, paragraph 5, last line.
Yes.
In the premises above, your honorable court may kindly be pleased to admit this application. This is the application that was filed by the workman, Lordship. Pass necessary so and so. And then after hearing the parties, please determine the amount entitled to the applicant.
So there's no question of reinstatement.
Now that he has attained his age of superannuation also, but back then he wanted the money, but then the award was passed in such a manner that the standing orders were not even respected. And eventually, he was awarded for reinstatement with 50% happiness. So that is why we are challenging this order. The law is otherwise also in my favor that this amounts to voluntary abandonment of service. So is the standing order. Had the standing order specifically mentioned that I am liable to issue a notice, then probably I would have not had a good case.
What is the last judgment that you are referring to?
Lordship, the
National Engineering Industries versus Hanuman.
yes, they've referred to a lot of, yes, but this, otherwise, this is the latest judgment, Lordship. No, the last judgment is by, it's a 1967 judgment. Yeah, strikingly similar to what has happened in our case. It's a 2-page judgment. I'll just read what has happened. Paragraph 1. Respondent Hanuman was in the service of the appellant. He took leave from 3rd to,
Yes, where are you reading?
Lordship, first paragraph.
This is an appeal. That's what it reads.
Yes, this is an appeal by special leave in an industrial matter that arises from the following circumstances. Respondent Hanuman was in the service of the appellant. He took leave from 3rd to 9/4/1965, and in that connection, a certificate from the employer so and so was produced. He should have joined on 10/4/1965, but he did not do so. His case was that he had sent another certificate from dispensary for further leave to one Prahlad Singh. Thereafter, he was given a fitness certificate on 19/4 and was required to join on 20 April. He appeared to report for duty on 20 April, but he was not allowed to join on the ground that his service stood terminated. As an industrial matter was pending at the time in which he was concerned as a workman, he made an application under 33A of the Industrial Disputes Act. Paragraph 2. The case of the appellant, on the other hand, was that Hanuman respondent was on leave from April 3 to April 9, which is about 6 days. on the basis of certificate from the district, the appellant however contended that no certificate was received thereafter on 10/4 to Prahlad Singh as alleged by Hanuman. Further, Hanuman did not appear to return till 20 April. Consequently, in view of the section swings of the certified standing orders, Hanuman lost his lien on his appointment, which is what has happened in our case. This appellant's case thus was that Hanuman's service was terminated automatically under the standing orders, and no order as such was passed by the appellant terminating his service. In consequence, there was no contravention of Section 33 of the Act. Therefore, Hanuman's application under Section 33A was not maintainable. Two questions thus arose to and so. Lordship, I'll refer to paragraph 3 from. On the second question, the Labour Court seems to have held that the service of Hanuman was not automatically terminated under the standing orders, and in any case, the appellant should have taken his explanation, and so there was denial of natural justice. For the service of Hanuman was terminated without an inquiry. The Labour Court therefore decided in favor of Hanuman and ordered his reinstatement with all back payments. Now, Lordship will come to paragraph 6. The discussion that was as the second contention raised by the appellant, it appears from the standing order in section G that a workman who does not report for duty within 8 days of the expiry of his leave loses his gain on the appointment. There is dispute between the parties as to what is worked in the standing order, which evidences the conditions of service. So far as as Hanuman is concerned, he admitted in his statement in cross-examination that under the standing order of a workman remained absent from the duty for more than 8 days, his service stood terminated. This shows that the workman understood the standing order in question to me. The standing order is inartistically worded, but it seems to us clear that when the standing order provides that the workman will lose his gain on his appointment in case he does not join his duty within 8 days of the expiry of his leave, it obviously means that his services are automatically terminated on the fulfilling of the continuance. We do not understand how a workman who has lost his gain on his appointment can continue in service thereafter. Where therefore a standing order provides that a workman would lose his gain on his appointment if he does not join his duty within certain time after his leave expired, it can only mean that his service stands automatically terminated when the continuance. Lastly, Lordship will see in paragraph 14, the order was award was given pre-certified based on this question.
Did he take leave or how? He just abandoned his.
The version that the workman has come up with is that he informed a few other employees of the company that he'll be going for 15 days. He will be taking a leave for 15 days. So there was no authorized leave. So even
So there was no leave
no
submitted
leave,
by.
no leave.
So that is verbal.
Lordship. So that is my case, Lordship.
That he will be taking leave for what? Medical leave or what?
No, he just wanted to go to Bihar, I believe. That was his stance. He wanted to go to Bihar for 15 days, and after that, he did not show up. Then he claims that he had some illness due to which he could not join within the specified 15 days also. So hence, he took 50 days.
So firstly, there was no application.
No application.
That means there was naturally no approval.
No approval.
So did he submit some medical certificate?
After coming back, he claims that he submitted some medical certificate, but nowhere in the trial, I think it is not a part of record. It is just his claim. In fact, section 12 of the Standing Orders Act, if the Lordship may kindly refer to section 12, this is also one of the formalities in the award. Section 12 goes on to say that oral evidence in contradiction of standing orders not admissible.
Yes.
Section 12, Lordship.
Yes.
It goes on to say no oral evidence having the effect of adding or otherwise varying or contradicting standing orders. 12 of the Industrial Disputes Standing Orders Act.
Industrial employment standing orders act or what? Industrial dispute? You said industrial dispute.
Yes. Otherwise, this was
Industrial
adjudicated
dispute.
before labor courts, but under it.
This is an industrial employment standing order.
Yes.
So not dispute. Employment.
Industrial Employment Standing Order. I'm corrected. Section 12 goes on to say that no oral evidence having the effect of adding or proof or otherwise varying or contradicting standing orders and finally certified under this act shall be admitted in any form. There is a statutory mandate also, plus there are judgments by the Supreme Court which says that standing orders are the statutory. They are the last and final order. So in that regard, the appendix
But only certified standing.
certified stand.
The document when it is another state, so I have some problems, but the good one is my case is covered. It will take some time to the matter.
Yes, para.
Para 4. Para 14. What happened is that there is a standing order. Automatic termination. In the case, we may call as a retrenchment. The person is retrenched, certain procedure has to be followed. That effort here, standing order act. In both the positions of the standing order act, each of the nature just has to be complied with. That is the case small, not in the. Some problem. I don't give some guidelines,
You
because
should have
it's like-
told me in the very beginning, then I would have wasted time. You should have got up in the very first instant and said that after hearing him,
all the different what you want to do.
I will give you time, I don't
can
want to,
contain-
but I'm just saying that you would have saved everyone a lot of time. Anyway, I will give you a date, but just let me record what he
What
said.
it is about, is the case of retreat.
No, whatever it may be. His basic case is that the labor court did not go into the provisions of the
Standing
standing orders, certified standing orders, which provides that no notice is required. That is his case. That's all. Anyway, right, we'll give you another date. I'll just let me record. Heard, Mr.
Why Kothari?
Huh?
Why Kothari?
White Potari, Leonard Council for the petitioner.
Paragraph 15, look,
Huh?
in my judgment, paragraph 15 is clear.
Page.
1993, EFCC 259. Or 8270,
Yeah,
paragraph 14 and 15, 16. You can invoke this standing order provision, but you have to comply with principles of the time. That is the right. And another aspect is supposed to be considered whether it is a case of retreat or not. If it is a case of retreat, then you have to comply with certain other mandatory provisions as contained in the Industrial Dispute Act. That provision is section 25M. Admittedly, that provision has not been complied with. These two aspects of this case was considered by the paragraph 4.
anyway, we'll adjourn the matter. Otherwise, look, if you're ready, I'm ready. You're continuing to argue, so I'm submission, so that's why I'm listening. If you want to continue and you want to dispose of, I am ready. But if you want another date, then no, don't make any more submissions. Let me record whatever I have heard, so we can fix for another. You cannot have your cake and eat it too. Either you want the adjournment or you want to dispose. What do you want? Heard, Mr. Worldwide Kothari, Leonard Council for the petitioner / management. And Mr. A. Das Gupta, Leonard Senior Counsel for the respondent number 2. The petitioner is aggrieved with the, where is their order? Award? With the award dated 10/5/2016, passed by the Learned Labor Code Body in reference case number 2 of 2015.
1 and 2, both.
In reference case number 1 and 2 of 2015. Under section 2 A bracket 2 of the Industrial Disputes Act 1947. On the ground that the no, not on the ground, full stop. The petitioners counsel submits the submit that by the impugned award, the he is dismissed or what is it?
Actually, you are not allowed to join.
He was not allowed to join them.
Management contention is that he has abandoned his service and he
The
has lost his lien. That is their contention.
Learned Labor Court has held that whenever any authority wants to discharge, dismiss or terminate any workman from service, the authority must comply with the principles of natural death.
Paragraph 27.
In the present case, no, it was not illegal. As the petitioner had not been allowed to join this service after having taken unauthorized leave for 50 days. Comma, the action of the respondent, action of the petitioner in not allowing him to rejoin service, not allowing the respondent number 2 to rejoin service was in violation of the principles of natural death. That's point number 3. That's point number. As such, the Learned Labor Court directed reinstatement of the, that's point number 2,
50% back.
with 50%
Back.
back with. Next up. He was working as what?
Electrician.
The petitioner's counsel submits that the petitioner was working as a electrician and had taken unauthorized leave for 50 days. And had taken unauthorized leave, unauthorized leave, and had returned for work only after 15. He submits that in terms of order 11 A bracket B and bracket F. Of the certified standing orders of the management there was no requirement of the management, the petitioner to issue a notice to the petitioner for his 50 days unauthorized absence. before removing the petitioner from the muster roll of the petitioner established. The petition counsel further submit that in terms of the judgment of the Supreme Court in the case of Bharatiya Kamgar Karmachari Mahasangh versus MS Jet Airways Limited, reported in 2023 10 SCR 859. Certified standing orders made under section 5 bracket 3 of the Industrial Employment bracket Standing Orders bracket close Act 1946 have statutory force. As as order 11A of the standing orders of the petitioner management provides for removing the respondent number 3 from his employment, from the employment slash muster roll of the establishment.
Otherwise, it would be voluntary abandonment of service, and then his name would be removed from the muster. So he would not technically be removed from his employment. He has voluntarily
Okay,
abandoned his job.
because it amounts to abandonment.
Yes.
Whatever it is. Provides that an employee's name can be removed from the muster roll of the establishment without notice if the workman is unauthorizedly absent for more than 10 days. Comma. There was no infirmity in removing is point number 3 from the master roll of the petitioner. After 50 days. Now, due to his 50 days absence, which amounted to abandonment of its service. Next one. The next one, the petitioner's counsel further submits that in terms of the judgment of the Supreme Court, in the case of Vijay S. Sathya versus Indian Airlines Limited and others, 2013 10 SCC 253. Absence from duty in the beginning may be a misconduct, but when absence is for a very long period, it may amount to voluntary abandonment of service. And in that eventuality, the bonds of service come to an end automatically without requiring any order to be passed by the further. in terms of the judgment of the Supreme Court in Syndicate Bank versus General Secretary, Syndicate Bank Staff Association and other. Reported in? Not reported.
Mentioned here.
Reported in dash, find out, look at your report. That if a person is absent beyond the prescribed period for which leave of any kind can be granted, he should be treated to have resigned and cease and ceases to be in service. In such a case, there is no need to hold an inquiry or to give any notice as it would amount to useless formality. Next. The petitioner's clause is subject. Next step. The petitioner's clause is thus subject that when the certified standing orders of the petitioner have not been taken into consideration by the learned labor court while passing the review over. The same would have to be set aside. Mr. A. Das Gupta, the learned senior counsel for the respondent number 3. On the other hand, submits them
Paragraph number 3, 4.
of your judgment.
Yes. 3, 4 and 15. They covered 15 and 16.
On the other hand, submits that in terms of the judgment of the Supreme Court in DK Yadav versus JMA Industries Limited, 1993, 3 SCC 259. The order of termination of service of an employee / workman visits the employee with civil consequences. And as such, fair play requires that a reasonable opportunity should be given to the employee prior to not allowing the employee to rejoin his duty. He further submits that as he is unwell, the matter may be discussed.
Paragraph 3 and 4. This is the crux of the thing.
No, maybe I'm not passing the entire order. This is just for my knowledge, so that next time I don't have to read the entire thing. The next time we hear it, I will record everything.
Oh.
I'm not disposing it off. Since you wanted adjournment, because otherwise I've got to read the entire thing again.
That's all right.
Yeah, right. That's what I think. Unwell, the matter may be posted on another day. List the matter on when? Any day when? Next week could be. 29. You want it next week? I know, that's what I'm saying, but next week you might not be, you might still have problems. You'll be okay.
When I can be covered by the second half also, sir. I can argue this matter in the second half probably. Hold on, I start with you.
The thing whoever is sitting with it.
Yeah.
Why not amendment of the municipal tax in the very expensive way? That you get it. That meeting was not yet held. We are waiting for that meeting.
When is the meeting going to be held?
They are informed that it was not held. Because
That is all right, but we want to know when it is going to be held.
the director. Be occasion. I do not mind, my lord, the meeting will be held and the matter will be clarified. Because there's a notification very clear. But to that effect, what you have said, Lordship, because of that portal, if we doesn't enter the amount, square feet that comes to 160, unless and until that portal has to be. So Lordship, government was also, it has to hold the meeting. No?
Okay, we hold a meeting. When? This writ petition is filed in 23. Should we direct you to hold a meeting? Look, this is an administrative affair. We cannot say that you have a meeting on this date, at this time. So you should do it on your own.
But the notification is there. The government, we are facing that notification that my rate of, the tax may be fixed on the notification.
Correct.
But we are having the difficulty because the same body has given that portal. When we enter the square feet here, say it's come, unless and until
So what body are you talking about?
director of director of municipal who issued the notice,
Director of Municipal Administration.
Lordship, Government of Department of Housing. And that notification, my lord, not new. It's a notification of 10/3/2023, before publication of the final system. It is in between the draft and final.
No, but what to do now?
That's the problem. My lord. We have to.
Should we call him? Should we call a director and the secretary to fix a date, or should we fix the date?
Starting meeting, we have no discussion, but there is a discussion from director of municipal.
To what effect?
That was said, that was already 14 July. It is this coming from 14 July. That is same. It was moved earlier.
That was placed, it was recorded in the order of 9 June also. Your secretary wants to have a meeting, but he is not holding a meeting. Even I want to have 20 rasgullas, but I am not, I cannot, I'm scared of diabetes. I don't know why he's not having. There's something to be scared about or something?
They must come up with this.
You see, I don't want to, this court
Yeah,
should not tell them, please have a meeting on this date. They are supposed to do it by themselves. You get information by next Monday. But next Monday court will sit at 2, so it's Tuesday. And if you find out when will be the next date, meeting held. Otherwise, this court will fix a date.
So what I suggest, my lord, let them agree on first week of the 5th or 6th. Meanwhile, they must come up with that everything to be finished. Thanks.
Correct. Heard Mr. B. Datta, Learned Senior Counsel for the petition. Also heard Mr. S. S. Roy, Learned Counsel for the respondent number 2 and 3. And Mr. G. Bokaliel for respondent number 4 and 5. In terms of the order dated 9/6/2020. it was recorded that in that the secretary to the government of Assam, Department of Housing and Urban Affairs, had written a letter dated 14/5/2025 to the Director, Municipal Administration, Assam, stating that the the secretary desired to hold a meeting to discuss issues regarding submission of a clarification pertaining to guideline number 15 in the notification dated 10/3/2020. However, as on date, no meeting has been held. List this matter on next para, list this matter on 6/8/2025, by which date the Secretary to the Government of Assam, Department of Housing and Urban Affairs should have held a meeting in terms of his letter dated 14/5/2020. This is the interim order to continue to. Okay. This is infructuous or what?
Should we have instructions in this matter? He sought for refund. Right?
Huh?
The petitioner had sought for refund of that spent amount. It has been refunded to,
In item 20,
no, 16.
item 16. Was that the prayer?
Prayer was to extend the settlement period.
Correct. Okay, so once this has been given, then no question of extending. Anyway, the period of settlement was only for 24, till 24, correct?
Yes. So,
And now it has been given to somebody else or what? You've got no idea.
24, sir. Both IDC was challenged. For this.
Okay, right. No one appears for the petition. From a while, Mr.
AK Bush,
A.K. Ghosh appears for
PNR.
the PNRD. The petitioner was settled with the Bazaar Style Ghat under Gauripur Anchalik Panchayat for the year 2023-2024. For the period with effect from 1/7/23 to 30/6/24. In person to a tender notice dated 4/5/2020. The petitioner has thereafter filed the present writ petition, claiming that he had been prevented from operating the market by certain people. And despite complaints being submitted by the petitioner, the authorities have failed to take any steps in the matter. The petitioner has thus prayed that the respondent authorities should demarcate the Dubri Char Ghat and the Dainik Bazaar, the prayer portion, to enable the petitioner to collect the levy as per the settlement order dated 5/10/2020. The petitioner had also made a further prayer, has made a further prayer, was extending the settlement period for another 9 months. Next. Mr. A.K. Ghosh has submitted the parawise comments
Is the last annexure. Annexure.
and the annexures to the same issued by the Chief Executive Officer Zila Parishad Dubri. Which is to the effect that the Ghat/Bazaar was settled with the petitioner for the period from 6/10/23 to 36/24 at the bid value of 4,04,627. And the petitioner had deposited an amount of rupees 2,90,000 only at the time of obtaining settlement of the Ghat/Bazaar. However, due to conflict of interest regarding the jurisdictional area between the lessee of the Ghat and the bazaar, the petitioner could not collect tolls from the Ghat/Bazaar. As the petitioner paid for refund of the amount of rupees 2.9 lakh. Sanction was accorded for refund of the said amount to the petitioner. He submits them. No. He submits the response process that's happened. That by an order dated 12/6/2024 issued by the Chief Executive Officer Zila Parishad Dubri. The petitioner's bid amount, the petitioner's uh, $2.9 lakhs, which had been submitted by him, is to be returned. Correct? Has it been returned?
Sanction has been accorded, okay, I believe there's.
Is to be returned. It would have been returned by now. Next part. The order dated 12/6/2027, 2024, issued by the Chief Executive Officer, Zila Parishad Dubri, is made a part of the record and marked as an exhibit. The contents of the same are reproduced herein below. Huh? A perusal of Annexure X shows that the part of the bid amount submitted by the petitioner has to be returned to the petitioner. Accordingly, the respondents are directed to refund the rupees 2.9 lakhs deposited by the petitioner within a period of 10 days from today. No, sanction has been given. From today, comma, if the same has not been returned to the petition. In view of the 8 of Annexure X, there is nothing left to be decided in the writ petition. The writ petition is accordingly closed. What is the weight? CM Vigilance said, when was the case registered with them? Twenty-five.
The central fund is over.
Huh?
90% central fund, 10% state fund.
So,
So what is for state fund is concerned of by oil submission.
your oral submission is not accepted.
By my.
You see,
Yeah,
that is a classic example, excuse me, taken by the state. And you see, this water resource division cases also. You have been sanctioned, say, you have made a project, say, for 100 rupees. You want central funding. You ask the center and the center has approved 10 rupees worth of fund. But you have given work orders for 100 rupees. You cannot say now the central government has to pay 100, out of 100, their share of the fund. When central government has issued only, has accepted only 10 rupees. That is your headache. That will not do. That kind of excuse will not do. Not a joke. If CM Vigilance sell a party, so we'll make them a party, I think. We'll make them a party. We have got to know the status.
But in their affidavit, they have admitted that the starting of 2000 case.
Huh?
Partly it, two parts are there. You are two parts.
Correct. One part to is,
One
one
part
part,
is
there is
One
no,
part is under, other part is not under.
correct. One part has to be paid. The other part, huh? Why
Starting
is
of
not being paid?
2001, one of which one is 61.
It labor fund or to labor fund.
And after that,
Mr. Council, you have asked someone to do work. You have asked someone to do work without any, and you have asked him, you make your work.
Part in actually what I get the better.
Huh?
In the two parts, first part was in the.
Yeah. You have to pay. Yes. You know, take an excuse all the time. Central government, central fund is not coming. Now I've learned that central fund is not, center is not responsible. And you are saying central fund is not, central fund is not. When you have got to show that the scheme was approved by the center for this many lakhs. Show me that. This thing is not been given. I will say that he has to give me 20 lakhs. If you say, why? I'm going to show proof. Same thing. You cannot say what you want. Not the way.
I got 5 of my people. After 2 weeks, though.
What? 2 weeks, what?
Giving the PM vigilance.
No, that is for one part. What about the other part? What about the other part? You're not paying. No, you see, there are two contracts, Mr. Kaushik.
It will take time, my lord.
There are two contracts. You have admitted to one contract. The other contract, there is some vigilance cell pending. Some case pending. Now for that, okay, we will ask for information. But for the other scheme, you give him. There cannot be an excuse. Central fund is not forthcoming. When you have got to show that the central government is liable, then only you can take the stand. Then you're also not very clear. You did not complete the works of 40% and 30%. Is there anything in the contract agreement providing for a risk and loss clause? They are not interested, neither. I know he did not break up that issue, but it is your duty to see whether there was a risk and loss clause.
They have admitted it.
Huh?
Number 14, they have admitted the amount.
You're right. Heard, Mr. G. Pathak, lawyer counsel for the petition, who submits that the petition was issued two separate work orders with estimates for rupees 85,99,000 and 1,92,49,400 respectively. Though the petitioner had completed part of the contract work, and which was thereafter surrendered in the year 2019, the petitioner has not been paid his dues for the contract work done by. Next. The affidavit in a position filed by the respondent number 4, who is the Chief Engineer, Irrigation Department, is that two works had been allotted to the petitioner, and the status of the two works and the payment to be made to the petitioner are as follows. This order dated 23/5/2025. Is 1 and 2, Roman 1 and 2. Next paragraph. As the affidavit of the respondent number 4 shows that the petitioner is still to be paid an amount of 13,52,161 for the Bordolong Lankajan LIS under AIBP for the year 2014-2015. The respondents are directed to pay the said amount to the petition, the said admitted amount to the petition within a period of 4 months, right? Period of 3 months from the date of receipt of a certified copy of the form. Next para. In respect of the work allotted to the petitioner under the Navanga Shibpur LIS scheme under AIBP for the year 2014-15. The respondent's case is that the balance amount of rupees 27,88,433 could not be taken up as the same is under investigation before the CM Vigilance. However, there is nothing forthcoming from the respondents' counsels as to why, as to what is the status of the CM Vigilance Cell case regarding the work done by the petitioner under the Nabanga Shibpur LIS scheme under AIBP for the year 2014-15. So, as such, so CM we repeat them. Who are they? As such, huh? As such, the Chief Minister's Vigilance Cell, represented by the Superintendent of Police, is hereby included as respondent number 7. Petitioner to submit a corrected copy of the past type to the registry within 3 days. Next, issue notice to the respondent number 7. Who accept notice? Mr. B. Over. Accept notice on behalf of respondent number 7. Petitioner to serve extra copy of the writ petition to Mr. B. Over within the course of the day. Within the course of the list the matter after 3 weeks to enable Mr. B. Gogoi to obtain the status report with regard to the claim of the petitioner under the Napanga Shibur LIS scheme under AIBP for the year 2014-15. From the respondent number 7.
Maybe. In this case, the other incumbent is not there. For that, we to keep the new income.
Yes, why not, sir? Yes, why not providing them the furnish of the certified copies of the electoral roll?
During the last order, the officer, which is, then case is not. So the
Mr.
B. Kumar on behalf of Mr. Udop.
P. Kumar on behalf of
Udop. Mr. Udop.
submits the he needs to file an application to impeach the present who?
election officer. Yes.
The present election officer now. Accordingly, let's start after 2 weeks.
On the doing of the, of like,
Mister,
On behalf of the
your name,
R Saham,
R.
R Saham,
Saham,
R Saham.
S-A-H-A,
Let's wait, like, I and I.
appears on behalf of Mr.
You know,
Dina. Respondent. Good response. It's not good. Respond number one.
this one, it's always solid.
What is wrong? What to do, madam? No one appears for the petitioner on call. And neither has the petitioner filed any application for impeachment of the new income. Miss P. Say, S-E-Y-E-I. P. Say appears on behalf of
Mr. Alan Das.
Anand Das, Senate Council for. No, this is a contempt. For,
What
for,
is
no- for number one. This is the matter. After 3 weeks.
After some time, I can do something. After some time.
Because of my legal year certificate of the next, in terms of filing of the case, my lord, the students, my lord, this review, should file, my lord. These are my mistake, my lord, because legal year certificate face 37. Next of kin certificate. Basanti was 67 years old. Natal was in the first son, 45, and Papi Mujumdar, 43, and Budu Mujumdar, 40 years. And next phase.
This was issued when? 22.
Yes, sir. I have annexed, I have annexed the voter ID, PAN card, all everything, original copies are also in,
I think you go to the civil court. What?
No, everything already stays, case was at this stage of releasing the amount, but because the year of election. But on that day, there's when matter was tutorial, matter was here, and at the relevant point of time, one APDP, wrongly, giving me by the blank, whole APDP only because of that, some. Otherwise, her L 1954, original subject.
Who is for the other side? It's the first time.
First time. Education before. Caribbean law. They have operating from the. Yes, ma'am. So can discrepancies only.
Correct. Because according to him, she had a child at 7 years and then the second
I
child
have
at 9 years.
Only because of my mistake, because my lord, the affidavit, wrong affidavit. I have annexed.
Wrong affidavit, but it's an oath.
No, that was not annexed, my lord. But I have annexed here, my lord, PAN card, voter ID, all everything.
You go to the civil court.
No, all are there, my lord. Kindly tell your lordship. I have annexed here, my lord. First one, my
You're
lord,
changing your entire case now.
76, my lord, your lordship, just my lord, date of birth.
You go to the division bench, you go in the pit.
Normally, your lordship can. Your lordship may, it's my lord, otherwise, my lord, this is the believing the amount, my lord. Only it's my mistake, your lordship, I can.
I don't know if it is your mistake.
Yes, ma'am.
I don't,
That was not mentioned in the, my lord, APDP. Also, my lord.
these are issues of fact. You see, even in your death certificate, the number 4 was different.
No, that was there, my lord. That this was not there, man, because that
The issue was not there, that's why, but that doesn't mean that this court will only decide the issues that you raise up. There are some issues that even the court sees and brings it up.
But dispute as my regarding the matter, date of birth, etc. matter. But I have annexed here all papers, matter, original or paper. Last of
I
my,
think you go to the,
and my lord, can you please-
you see, your husband died when, 1983?
I have mentioned here, my lord.
No, I'm asking you mentioned it or not, whatever, I'm asking you a question. 83. You filed a writ petition for family pension when? 22, 21.
Yep.
After 40, and after how many years? 38 years.
Here, my lord, I have annexed.
I think you go to the civil court. Or you, I'm not passing on them. You go to division bench.
But otherwise, my lord, I have annexed all papers, my lord. Okay, at this stage of all verified, I have annexed here, can you please the last letter, my lord, last letter, page 35, my lord.
When this court has said,
All of verified, my lord, that's why, my lord, still verification are also done, my lord. Because the letter of director.
where is your marriage? Where is your marriage certificate or some marriage? Where is the document proving your marriage to your
And they
husband?
delivered for the plan for the old, but she was possible, my lord, 67, my lord, I have annexed here, my lord.
Hey, was there any declaration made by your husband that you were his wife?
68, 69, there was no such type of marriage certificate, my lord.
What?
However, there was no such
That's a concept.
for issuing marriage certificate, country young law.
Yes, this is true. Was there any family declaration made by your husband? That you were, well,
Next of his certificate, while after verification, it was provided.
during his service,
Best certificate,
during his service,
yes, madam.
he married when? He married the petitioner when?
It is called as 68, 69, madam.
68, 69.
68, 69,
And he died when? 83.
83, madam.
So, all those years of marriage that they were together, he was in government service? Correct?
Yes, sir.
Is there any family declaration saying that you are the wife?
It is there, madam. It is
Show
record.
me, show me. That's what I'm asking. Show me.
Yes, madam. First of all, your chip and is page 31, my lord. Relaxation was sought for, madam. Page 31.
Mr. Councillor, do you understand the question that I'm putting to you?
Yes, madam.
I am not asking for apple. Okay, I'm asking for a pineapple. So please show me the declaration made by your husband showing you as his wife. So it is not with you. Then why are you saying it is here? When I ask you for something, please answer that question. Don't take me somewhere else. Ah. I want to go and sit in the park. I don't want to climb a tree. So don't take me somewhere else. I've asked you a simple question. Please answer it simply.
Yeah.
And you have not been able to show that. You're a government servant. You go, I will reflect. I will dismiss your reviews.
My learned friend also can.
No, it's not a question of your learned friend. It's a question of you satisfying the court in the first instance.
They want that may be given, my lord.
No date given, sorry.
Copy of the same, madam.
Yeah, you see, I don't appreciate when people try to lead me at the wrong garden path. You answer my question fairly. If you don't have it, say you don't have it. But you said it is there. Then you-
Information it is there. The relaxation.
Show me, where is it?
Page 31.
I've seen page 31. Where is it?
Yes, my lord. This is good reference to survey. I am directing him that as per the director pension, dated pension, you are requested to move in the government of they are,
Mr. Council, this letter is of 2024.
because relatedly we, my lord, sought
He
for,
could not have
pension.
written his family declaration while in 83.
That
He died in 83. The family declaration has to be before 83.
before
Yes.
established the proposal.
So where is the service record? Nothing is there.
In the service, developing, I try one 7 days time.
Is there a service book, either the service book or a notification regarding this? If it is there, it would be useful document.
But there is nothing here. I'm
There's
not,
nothing here.
I'm not going to keep this pending.
The record file already prepared by the.
Mr. Council, this is a review. This is not a writ petition.
Yes, my lord, sir.
This is a review. I cannot go on a roving inquiry in a review petition.
They are preparing, they are willing to, the petitioner can produce. my
You
lord.
withdraw this review. When you get it, you file a fresh, then we'll see. Otherwise, I cannot accept this review as it is. You see, a review cannot be an appeal in disguise, nor can it be a means for having a review inquiry, roving inquiry. It is only to see that a mistake has occurred. Show me the mistake. Show me the mistake. You answer my question.
Because
When-
at the relevant point of time,
Okay, right.
it was wrong. my lord.
Heard, Mr. Dismiss, huh? Heard, Mr. Das, doesn't pass for the petition. I heard, also heard Mr.
B. Sharma
V. Sharma.
for the accountant,
For the
accountant.
Accountant General Office. Anybody else? Miss S. Kemprai appears for respondent number 3 to 7. Miss Miss B. Dekha appears for respondent number 1 and 2. The present review petition has been filed for setting aside the impugned order dated 17/3/2025. Passed in WPC 7-93 of 2021. By which the petitioner's prayer for grant of family pension has been dismissed on account of there being serious disputed questions of fact. Next one. The now WPC 7-93/2021 filed by the petitioner has been dismissed on account of the facts stated by the petitioner's counsel that showed that the petitioner had apparently had her first child
Yes, 9.
with the deceased husband on 28/12/1970. The second child was thereafter born on 13/10/1972. Wherein the petitioner would have been 7 and 9 years of age respectively at the time of bearing her children. The petitioner's husband had allegedly died on 5/6/1980. The petitioner's alleged husband had died on 5/6/1980. And the writ petition for grant of family pension was filed on 21/12/2020. This court had dismissed the writ petition on account of the fact that the petitioner had on account of disputed questions of fact which included the petitioner not being able to produce any document to prove her marriage to her alleged deceased husband, and in the absence of any family declaration made by the petitioner's alleged husband, showing the petitioner to be the wife of a government servant. Further, a perusal of the death certificate of the petitioner's husband showed that though the petitioner's alleged husband had expired on 5/6/1980, the death was registered only on 2/3/2004. That is after 21 years. The number four, inverted comma, number four in the death certificate was also clearly different in handwriting, even to the naked eye, as reflected in the order dated, impugned order dated 17/3/2025, passed in WPC 7/9/2025. Next one. Though the petitioner has now provided has now the next document allegedly showing that the petitioner is allegedly showing that the next documents showing the next of kin of the showing allegedly showing that the petitioner had 3 children with her deceased husband and not 2, as reflected in the impugned order dated 17/3/2025. The petitioner has still not been able to show any family declaration made by the petitioner's alleged husband, showing the petitioner to be the wife of a government servant. On considering the fact that there are serious disputed questions of this court is this court does not find that any case of review has been made up by the petition. The review petition is accordingly dismissed. However, the dismissal of the review petition would not bar the petitioner from approaching the civil court for proving that she was the wife of the deceased government servant, to enable her to claim family.
Alright.
Basically, the
Repetition otherwise was allowed by law.
Huh?
By your lordship, the repetition is allowed. So, that was actually made. But even though the repetition was allowed, granting that the petitioner the BCLR, that's what the Ministry of External Affairs, the rate at which is because the retail, the one which has challenged was quite. And we will also directed them to pay as per the Ministry of External Affairs rate and any subsequent enhancement. At the time of the hearing, your lordship, they actually pointed out with regards to one particular order, one subsequent enhancement order, wherein they had said that we had granted them as per the MEA order, but they have not applied the MEA order. Now, at the time of compliance with your lordship of judgment, they said that we follow the MEA order, your lordship judgment says pay them, pay the petitioner and 99,000. So the MEA order says something different. MEA order says that the petitioner is entitled to 1,10,000. And they, even though the order says that we are following the MEA order, the order itself of the Board of License says that only 19,000.
Let us see.
So if I may take your lordship to the judgment, your lordship, then everything will be clear. Findings start at page number 30 on.
Uh, uh, I think the other, we'll take it at 2 o'clock. No, no, I don't do right now, but I want to do the other matter. I want it better. Because the parties are here. You dispose of after.
My clients are yes, but my order. I just spend all the way, they present in the board.
If the applicant has signed the form, lordship,
Huh?
signed the taken away form of the account.
Sign the what? Account opening form.
They should have been, as per my lordship order.
No, no, if they signed it, it's okay.
Well, that is where the catch is, my lord. That is why we wanted to hear that. So I have got my clients here. The last time when my lord come to the order, my lord, they had been, last time they said they were in Agartala, the plane could not land. This time also they are not here, my lord. They sign it and they will not take it to the bank. That is the problem. So if they come to the court before my lord, then everything is settled, my lord.
Also communication of the informed.
Matter is subjudice. When the matter is subjudice, they are saying that we'll open an account, you come here, come there. They should come here. My lord has already ordered their appearance.
You are for who? Dromos. So Dromos are supposed to appear personally. This is what this court has directed. Huh?
He signed the form, lord.
You signed the form.
And also.
Dromos have signed and who has also signed?
Okay.
Actress has also signed. So it's there in the live streaming. You can always YouTube, you check.
My lord, then, if I may pay, my lord. My lord, may letter, may give us 10 days. Within 10 days, we'll sit together, go and open the JD account, then come back to the court and pass on the complex. They also need to play.
Yes, who is for the railways? Railways. Mr. H. Gupta was here.
Yes, yeah, no.
Yes. Anyway, so no deposits are to be made. Deposits are being made to your account? No. Because if you see the order pass in the writ petition, it says henceforth. Henceforth would only apply prospectively. It cannot be retrospective. So henceforth,
Prospectively, they have provided it to court. They have transferred money to the account despite of the court's order. That's why item number 1 has been listed before my lord. And my lord, within 10 days, my lord, we will, my lord may direct both the parties to seek to debtor, go to the bank, open the joint account and file complaints affidavits by both the parties. We'll also file an affidavit, let them also file it.
yes, you're appearing for whom?
The national project is going on at present.
Huh?
The national project is going on. At present, and possible provision is not present before the court.
Huh?
But already signed all the JB documents.
You are appearing for whom?
Appeal for the petition.
Huh?
Applicant.
Applicant for Dromos.
Dromos.
And you are appearing for whom?
Dromos.
Dromos. So only one of you should appear. Who is appearing for Altis? So this is, which is Altis signature? Which one is Dromos and which one is Altis? The middle one is whose?
What Altis and Dromos. First one is Dromos and.
Dromos, and the second one is Altis.
Altis, right. Right.
Okay, yeah, what is your name?
Hiranmadan.
Hiran?
Hiranmadan.
Hiranmoy Devnath. For Dromos.
Okay.
So then, you all open this account.
In 10 days, we'll also cooperate and we'll file complaints affidavit, both the parties shall file complaints affidavit for my lord. But they should have, they have kept this honorable court waiting for 1 month, my lord, that they'll come and appear. One day the fight is diverted, one day they are busy somewhere, my lord.
No, they've kept you waiting.
My lord, but since before my lord,
Okay, we'll pass this order in the IA or in the contempt?
in the IA, man,
The IA,
in the IA,
Right.
1922.
in the IA, right. Mr.
Hiranmadan.
Hiranmoy Devnath appears for the applicant. While Mr. H. Sharma, R. Sharma appears for
Respondent number 1,
this one number one.
sole respondent.
Mr. S. H. Gupta appears for respondent number. Huh?
Railways is not a party to IA.
Hmm? There are there. They are there. Okay, Mr. RKD Chaudhary appears for respondent number 225. No one appears for respondent number 6, that is MS DECPL KTC ALTIS JV. No, this is a joint venture.
Joint member, Altis, man, Altis.
Altis is separate.
Altis is separate, but my lord may report that Altis is not appeared.
Okay, just don't say 6. No one appears for Altis. ALTIS. Next para. Mr. Devnath, so Devnath, has submitted the current account opening form for non-individuals for the SBI and submits that the 2 signatures in the said form have been made on behalf of the applicant and ALTIS. He accordingly submits that with the said form that has been submitted to this court, a joint venture account in the name of the respondent number 6 can be opened after the respondent number 1 gives his signature. Listen. So where is it going to be opened?
The sit can be open within 10 days, and both parties are maybe directly to file compliance affidavit.
And this will be kept at home.
It will come back to them, my lord. We'll go to them and we'll together with.
When? Okay, right,
10 days, man.
right. The,
Paying for signing today, because all the.
I'll let them sign today, sir.
Yes. Yeah, yeah.
The,
That's what number one says.
yeah, give it this back. The current opening form for non-individuals for the SBI, which has been signed by the applicant and artist, has been handed over to the council for the applicant to enable the representatives of respondent number 1 to give their signature,
Who's present in the court.
who are present in the court today. Sign it. Full stop. Next paragraph. As the signature of the representative of the respondent number 1 has been made in the presence of the court today, who is the authorized signatory? Is he the authorized signatory? Yes, miss. Is he the authorized signatory?
He's a little country.
Sign. What have I said? Has been made in the current opening account form. The parties shall ensure that the JV account is open within 10 days from today and submit a compliance report.
Who's the party?
Compliance report to be signed. Compliance and to submit individual compliance report
Affidavits
by way of an affidavit.
by both of them.
Naturally. But, next post up. Leaves the matter on. You did. Today is what? 16. Please. Whenever 28, 29. No, today is what date? 16, no? 29. Hopefully everything will be closed by then.
I don't, and I didn't know one matter. Notice of the candidate.
List the matter, this item 1, list the matter on 29 August. Oh, yes, it is again. No. And you see one thing, in the order on the writ petition says that henceforth. It is prospective, it is not retrospective. Okay, we will close the content.
I have.
We'll reflect in the application that no payment should be made, no henceforth of payment. Okay, in the application, you're right.
That's the kindly, my lord, I paid it kindly, my lord, peacefully, together on 29.
Why?
My lord, what is that to keep my lord come to your order, my lord, henceforth. That was a consent order, my lord. My learned friend was also here on that, present in that court. They did not raise it, what they said, there was nothing left.
So after that, they passed, after that, they gave the money.
They give
Okay, don't say anything. Leave it like that. In the contempt, right, this is the matter on
29.
Nine.
And my lord, my prayer is that put a matter to be parted.
I parted,
My lord, because my lord, otherwise,
nothing to be decided here. It's all,
my lord, but for your lordship is acquainted with this matter, so my lord, may kindly be kept further.
nothing, anyone can do. No, you give this back, huh?
My lord, may kindly keep it pardon.
Okay, this is the matter, this is the matter, so as part of. Good. I've got a meeting at 1:00. Otherwise, I could have taken up your matter. 2 to 10 or something. Now there is a lot of movement. So tomorrow we'll have one reference. Day after tomorrow, another reference. And in the same evening, a new chief will be arriving. And the content of it goes together. So you make sure that it's compliant. And please submit an affidavit. You tell me. Please tell Altis, your friend Altis, to submit.
Lordship, review petition, I don't have very zero problem. Basically, in the case of the petitioner,
Now let us go to the document.
the Lordship, if I may take the Lordship judgment, then the Lordship would be.
Take it.
Because if I may take the Lordship to page number 29, where the anomaly goes, there are 15.
Page 29. Don't make it too long. This is a review, remember.
Yes, sir. With taking whatever it is. Learned here, while referring to annexure R2 of the affidavit submitted by the responsible one, published that in terms of the letter number 24, digit 6/4/2015, issued by the Undersecretary to Government of India, Ministry of Defense, Department of Defense, Motor. The PCA payable to officers drawing grade pay of 56,600 per month and above, but less than 8,700 per month, was 89,561 per month, and the same was enhanced to 99,608 per month with effect from 1/4/2000. Next paragraph we are not talking about. Next, I may take you also to paragraph 16. The observation of the lordship. Yes, order dated 1/5/2012, issued by the Ministry of External Affairs, South India, clearly shows that the PCA is able to cancel and state government restrictions to done for officers drawing grade pay of 6,600 and above, but less than 8,700 per month with effect from 1/4/2011 would be 93,000. The letter dated 23/11/2012, issued by the Ministry of Road Transport and Highways, Port Roads Development Board, states that the ad hoc increase in DTA with effect from 1/4/2011 payable to great employees having done under Project Jantak in accordance with Government of India, Ministry of External Affairs dated 1/5/2012, and even number dated 24/5/2012 for officers of the central and state government. During service of deputation done would be as per the chart given. As per the chart given, the letter dated 23/11/2012, the DTA rate for officers drawing grade pay of 6,600 per month, but less than 8,700 per month, is 82,119 per month. A perusal of the two different figures given for PCA in terms of the order dated 1/5/2012 and letter dated 23/11/2012 shows that a mistake seems to have been made in the letter dated 23/11/2012. In view of the fact that the order number dated 1/5/2012 has provided that the PCA should be 90,000, and the same has been accepting the letter dated 23/11/2012 issued by the Ministry of Road Transport, the PCA rate payable to petitioner cannot be 82,000, it should have been 93,000 per month. Next paragraph is important. That is where the anomaly arose. Be that as it may, the letter dated 6/4/2015, which is annexed with Annexure R2 in the affidavit of person for respondent by the Undersecretary to the Government of India, Ministry of Defense, which is Annexure R2 of the affidavit filed by respondent number 1, states that the President of India has sanctioned the ad hoc increase in PCA with effect from 1/4/2012, payable to great employees serving in Bhutan under Project Jantak, in accordance with the Government of India, Ministry of External Affairs, letter dated 5/6/2014 for officers of the central and state government of India due to service and reputation for Bhutan. Letter further stated that the revised rate of PCA with effect from 1/4/2012 and 10% with effect from 1/4/2013 for different categories would be as per the chart provided in the letter. As per the chart in the respect of officers drawing grade pay of 6,600 per month, but less than 8,700 per month, the PCA rate would be with effect from 1/4/2012
89,561. The BCA rate per month with effect from 1 to 2013 would be 99,608. As the petitioner had joined his court at Tantak around 26/7/2013 and had remained in court till May 2016, the petitioner would have been paid BCA rate of 99,608 per month. Further, if there has been any enhancement of BCA subsequent to 1/4/2013, the petitioner should have been paid given this benefit of the same. However, the petitioner has apparently not been given this due in that. Now, your lordship has kindly observed in this paragraph itself, they relied on the Ministry of External Affairs letter dated 5/6/2014, which was not annexed at the time of the petition. They are only annexed as R2, the order of that letter dated 6/4/2015. That I have annexed now in the review petition, because the rate which they are stating that it is 99,000, it is not that case. Now, if I may take your lordship to that annex R2, 6/April 2015, which is annex B at page number 37. Yes, serial number 3. They had, in the first paragraph itself, they stated, in accordance with the line is seventh line. In accordance with Government of India Ministry of External Affairs letter dated 5/6/2014 for officers of the central and state government during service on the. Wait, line. In the annexure, B page 37 of the results. That's not the opening. That's not the opening. I'm likely to refer to this ministry's letter dated 12 June 1989 and the subsequent amendment last done, the RDB letter event number dated 23 November 2012, which was struck down by your lordship, and to convey the sanction of the President of India for ad hoc increase in Bhutan compensatory allowance with effect from 1st April 2012, payable to the great employees serving in Bhutan under Project Tantak, in accordance with Government of India Ministry of External Affairs letter dated 5 June 2014 for officers of the central and state government of India during deputation service on deputation to Bhutan. Now, if I may take your lordship to serial number 3, which is applicable to the petitioner. Officers drawing rate pay of 6,600 per month and above, but less than 8,700. The amount here written is 99,608. Now, if I may take your lordship to this Ministry of External Affairs letter dated 5/6/2014, which is at annexure C, page 39. And relevant page 40. Serial number 3.
Yes.
The amount is 1,10,520.
Page 39.
Page 40. Serial number 3. They are stating that they are following this MEA letter dated 5/6/2015.
This is 5/6/2014.
14, I'm sorry, for 5/6/2014. They are stating in the 6/5/2015 letter that they are following the 5/6/2014 MEA order of BPL. Whereas the amount which is mentioned in serial number 3 in their letter, annexure B, is 99,608. But the MEA letter says 1,10,520.
This is a letter by who?
Which letter?
Ministry of External Affairs.
Excel effect. Annexure B is the letter which they are stating that he is getting 99. Obviously, I'm getting 99.
Okay, so there are two different figures.
Yes.
So there is one letter of 5/6/2014. Correct?
Yes, we should put
Right.
MEA.
MEA. Where the figure of the amount payable is 110,520. Correct?
Yes.
And then there is the other letter,
6 April 2015.
6/4/2015. Where that issued by defense,
Ministry of Defense.
where they have said that it is 99.
90. So the earlier order, which is 23rd November 2012, was struck off. Same issue.
Which order?
23rd November 2012. This was struck down by your lordship because of this anomaly. Because they are stating in one hand, they are following MEA order, but MEA order says different figures
And their order, the Ministry of Defense order says a different figure also. So this was had to,
Let us see this 23 November 2022.
it's an extra two of the rate petition.
You can take the second copy. Sir. Oh, he.
This is not any of the big.
Oh, he's not any of the repetition.
Oh, yes, we do believe in that way. Yes, we do. Okay, acha. Okay.
But this 23/11/2012, this is issued by the Ministry of Road Transport.
At that point of time, it was under Ministry of Road. We are a team. So here, this 82,000 was the serial number 3, 82,119. Wherein also they stated that it was that for one, first May 2012, May order. The first May 2012, ME order says something different. First pay, the ME order is at page number 28. Huh? Page number 28. Sorry. Page number 29.
This is a review or what? What is this?
Your Lordship, that is what that particular anomaly is kept saying. Just that, if I may take your Lordship to page number 29. Yes. The ME order says 90,031. And their order says 82,000. This was struck down. This 23rd November, because it was not in compliance with the ME order. So this always happens because this it gets an end year after year. It's not year after year, every 2 years. So in terms of this, welcome which was we confirm your Lordship. I think the Lordship directed them to pay any further enhancement which might happen to this it as per the ME order. That should be given to the petition. But
I'm not getting it. I'm not getting the. No.
29.
Your basic case is that 5 June 2014 NDA letter. So I got that. So how is it connected? So this June 2014 NDA about the letter provides for 110, 1 lakh. And this, so it relies on, and however, the subsequent letter issued in 2015 by the Ministry of Defense provides for 99 lakh, 99,000. So
That is where actually what that was actually frowned upon by your Lordship, because in the earlier order, which was actually amended by this 6 April 2015, 6 April 2015 supersedes that 23rd November 2012 order.
this is by different ministry.
So, because at that point of time under Ministry of Surface Transport, then it was the PRO organization was in 2015, it was came under Ministry of Defense. That has been made by the senior, the own application of person. And has been taken the definition, it's at paragraph number 15. The statement. Your Lordship, paragraph number 15 clearly observes that this discrepancy doesn't determine.
So this letter issued by them, issued by the officer in charge of the DGBR on 25/4/25. I think you've been given a letter here. Okay. So it says here, payment of servant wages will have to be subject to certification by the concerned officer. The petitioner eligibility comes under the category of post at serial number 5. 3. Thus, after deducting the amount on account of servant complement or rupees 5,000 so into 2, that means 10,912. So, so this, so this service, the servant complement has been deducted. With that deducted, it comes to 99,600.
But, there's a big but, why? The same rate, if a lordship, if I take the page number 40 of this review petition regarding the current allowance. What that is very. Page number 40, just below the table. Page number 40.
This will be a review.
Your lordship, just bear with me, your lordship. Just bear with me. This discrepancy is actually kept in the no, disputing that. Because whatever material was passed an order, based on that, we have made something. It may be right, it may be wrong. If it is wrong, then that is a case for a question. It is not a case for review. We say we have paid, but the servant allowance or whatever. If he is agreed by that, that's the first one. That is not never take order ever issued to the capital. I am just made aware right now. In fact, it's a lot like only below the page number 40, just below the table. The existing complement of 2 full-time local servants to the title officer will continue to be at the same rate till further order. Now, the interesting part here is the BC rate which is payable to army officers and all other group B officers is in terms of this MA order, which is 5/3/2014. How I say so, your lordship, I place one particular paper, this particular strike on the anti-pump clearing allowances, wherein army officers, they are being paid because on last occasion, also wherein what would happen to other army officers under the same Ministry of Defense, whether they are getting this BC rate in terms of this order or in terms of the ME order. Now, the order, the letter, perhaps with my learning here is placed before lordship, perhaps it will reflect that the army officers who are posted to start, they are getting the rate as per the MEA rate, as well as the group B. How I say so, your lordship? If your lordship peruses through serial number 5, 6, and 7 of this same page number 40, the pay proposed this year is 64,589. 58,268 and 29.
No, you see, these are all proposed BC, okay? This 5th June 2014 is all proposed. It's the word used is proposed.
No, it is sanctioned.
No, whatever. But this is of 2014. What is, but then it is 2014, 2015. Does not parrot this amount reflected in 2014.
Lordship, it was proposed and it was sanctioned. That's why page number 39 says this sanction, this all on confirmation above order, it has sanctioned. This proposed, it was a proposed PCA rate and it was sanctioned by the president. And it hereby accorded for increase at 8% with effect from 1/4/2012, before 39. It was proposed and it was sanctioned. So even though the language says proposed, but it was the date. And for your lordship, convenience, your lordship, at page number 38, the same rate for group B officers. If your lordship kindly grant me this audience. Serial number 5617.
Look, I think we are going far beyond, I think.
Even for your lordship, understanding.
I
your
mean,
lordship,
you have taken so much time for a review. I mean,
lordship, I just want to make the lordship understand that this particular anomaly has led to because of this particular all
document not being there.
because this urban allowance, this is paid to any officer, the army officers who are posted in Bhutan. And this is there in this handbook itself. I placed that before the lordship on last occasion. Therein, the servant allowance, how it is treated. The servant allowance is to be paid. It says that existing complement of 2 times local servants, the entire officers will continue to get the rate of 5,456 per month till further order. And this has to be claimed by the officers for protection. So,
Claim.
claim.
Did you claim?
You will never given this because the deduction is lower. That is why. That is why the annual goes. The amount they deducted is
I think it's by the fit. You did not claim.
First, they have to give me guarantee.
But they have to give you what?
That the PTA rate as per any order.
No, unless you claim your entitlement, where's the question of payment?
You know,
You see, like I'm a judge. I get a certain amount for furnishing. I have not used it up. I have not used up the amount that I can use. That doesn't mean that I can claim it anytime later on. Once the period has gone, that's gone is gone. If you don't make a claim, that's your problem.
no, this is different. Here they have to pay me for as per the MEA order. MEA rate says 1,10,000. So out of that 1,10,000,
Provided you have got the service, you make a claim for the service.
provided I engage you because provided I first get paid for.
No, unless you engage the service, there's no question of you claiming.
But that is a different issue altogether. It's a complement of BCA, you know. And this BCA in fact includes the servant allowance. That is there in the 2001 order. It is very ridiculous. I mean, take care of the risk to become. But that is,
You see, I don't have a problem with this, but the problem is I don't know if it's the right thing to do.
but
We are going far beyond now.
yeah, but I'm not stressing on that particularly. But ultimately, your lordship observed at para number 18 itself that this is wrong. This 93,000 which is stated in the ME order, if we have to go by the which was actually challenged when it was set aside by your lord. The 2012, November 23rd, November 2012, Ministry of Shipping order was set aside by your lord. Because the BC rate which was given by them at that point of time, which was 82,000, was not in compliance with the ME order, which said that 93,000. Now that was enhanced by this 2016 order, stating that 99,000 and the ME order says 1,10,000. So all I'm saying for the lordship is that in the order itself, it reflects that I should be granted 910,000, but it should have been 1,10,000. That is what I'm just saying. As per the ME order. And your lordship, in fact, observe that any subsequent further enhancement in the future should be granted. That I have not granted. This is an enhancement in the future, your lordship. I have also annexed all the enhanced feature orders, your lordship. After 2015, I have also annexed the 2016 order, wherein the BCA rate was further enhanced to 1,14,000. That's enhanced every year after year. But I was not granted those.
Yes,
Lordship, I would take the lordship on second to the past. Now, ultimately, lordship, we agree that So, paragraph 18, at page 31. Be that as it may, the letter dated so and so should not have the secretary. History of the is annexed R2 of the affidavit filed by the respondent states by the particular particular sanctioned the amount of the well, we are here, right? Serving in part of the project number. It was not in accordance with the history of external affairs, 560. For officers of the central and state one, in service on the letter further stated by states of state, the rate of 8% set from thousand work, another rate of 10% for different categories as per the chart provided or letter. As per the chart, in respect of officers burn rate pay of 6,600 per month and of less than 8,700 per month. The PCA rate per month with effect from March 4, 2012 would be 9,600 and the PCA rate with effect from March 4, 2020 be 99,608. As the petitioner have joined, this shows that number start of 26/7/2013 and had remained in the said place till May 2016. The petitioner would have to pay his year to become 99,608. Further, if there has subsequent to 1/4/2015, the petitioner should have been given the same. However, the petitioner, your lordship has passed on the what the pay is. Okay. What have to be paid to. Now, in accordance with the determination made by this honorable court, and it is not that the document at page 37 was not with the page. It was very much clear. Now, if he says that whatever is there is incorrect, ask an order, that I not because that would be something the lordship has made a mistake. The mistake can be corrected only when it goes on the field. When the court has passed an order based on the days before it, I do not think it would be what we do. And in terms of the lordship, he has released in the payment. Now he's contending, no, it should have. If it should have been higher, that calls for a fresh case. It's not a case for me. Yes, I may admit that I have committed a mistake. I have given him less.
But one problem would arise. If a review is not made, or if he doesn't file an appeal, then this order will still remain. That will block it.
No, not. He has to file a fresh case. Contending that whatever has been.
Yes, that was decided on the basis of those materials.
Yes,
But since it did not consider this
yes,
document,
that,
this case would not bar the court from coming to different finding on the basis of this document.
yes. So that would be a fresh matter. Now it has come. So in my humble certificate, this is not the case of court. If I would have been in his place, I would have filed a petition. I don't.
And we can fine,
If he has filed,
because at the time of contempt for compliance, because I did not get the amount. I filed a WT. Lordship directed me to file, at the time of contempt, liberty was granted to file a review petition. Then I filed a fresh writ petition. So at the time of after filing fresh writ petition, again I was directed to file a review. Lordship.
Where is that?
I have annexed those orders, Your Lordship, right from the contempt, page number 53 onward. Order dated 24/1/2024. In third line from the in view of the above, by granting liberty to the petitioner to educate his grievance if any pertaining to the correctness of the computation of the amount paid to him by the respondent in terms of the order of the report, this contents is good. Then liberty, after getting liberty, I find the writ petition 518 of 2025. Therein, again, your lordship, observe that review would lie and not on a writ petition. Here, why I'm educating the point of review, your lordship, a review would lie with an error.
But you said passed based on a wrong and misleading fact.
Yes. Because this wrong and misleading fact is this, the Ministry of Defense order says 99,000, when they are saying they are following the ME order. But the ME order says 1,10,000. That is what, and the earlier order which was quashed by your lordship, the same issue very. The earlier order says 83,000, and then the ME order says 93,000. This was subsequently enhanced by 2015 order. So ultimately, even though the writ petition was allowed, and your lordship directed them on the basis of the false submission, that is 99,000. 99,000.
Objection to that, your lord. How can it be a false submission?
I'm not saying one, that it's given a false submission. The department has actually provided a wrong inspection. Because they have stated that this is as per the ME order, but the ME order says something different.
No, you see, it is not a false submission. It is, it's not a wrong and misleading fact. It is a fact. There's nothing misleading about it. It's only a thing that there are two different facts there. I mean, two different statements are there. Two different amounts, figures are there. When two different figures are there, there's nothing misleading about it. The only thing is that whether either one of them is the correct one who could have been decided. So this is not exactly correct.
Your
So it
lordship,
has been-
kindly go to page number 36 of the judgment itself. Your lordship, set aside this 23/11/2012 order.
Okay, one thing. Is he entitled to those two servants? Yes. He is entitled to it. What to do? Otherwise, for him also to get stuck up in legalese and procedure law. I think if he was entitled to. But what I don't understand is, in your letter, you have said that the amount of rupees 99,608. The difference in BCA sanctioned by Censo, order Censo was caused primarily on account of deduction of the complement of two full servant components as their eligibility category of the officer. So why was this deduction made? Deduction made by mistake or what? You got the letter, I think, Mr. Arkady. So this is the basic thing, like, thing is that it should have been 110, but here we have given him 959. Yes. Due to the 2015 letter. However, the 2014 letter provides for 99,000. Now, the reason is because that salary of two servants has been deducted the subsequent day. Why was it deducted? That is why was it deducted? And was he eligible for those two servant salary? If he was eligible, he could get it. It doesn't matter. Why go round and round about this holy? Otherwise, he has got in a writ. Report. So, for him being going to get stuck in a, endless circle of going round and.
It should not. Your lordship will take it up.
I can think we can adjourn it. Monday to no, because Monday I'll be having meeting. Or this will be a school. All courts will function as school. Because the thing, the court takes place. And there will be a collective now. But the case is around 1 hour from here. Traffic, where is the traffic, so you get caught up with you. so. Let me visit there because the thing is that, you see, the issue is, I don't know, I might be, I I'm not sure. I hit double DB also for that, might. But Monday, much better.
So, if your option is there, like if you want,
Just review matters, so it's up to me now. Only thing is that, you see, since he has already gone in a rig, so let us resolve the issue. It's a matter of 10,000 a month for 3 years. 2 years. Huh? 2 years.
That amount to be, not May 2015, May 2015.
Okay, so 2 years. So it would be basically around 2.4 lakhs. And it is eligible, if not eligible. Okay, right. The issue is with regard to the difference of the PCA to be provided in terms of the letter dated 6/4/2015, which has been made in pursuance to the earlier letter dated 5/6/2014. In terms of the letter dated 5/6/2014, the petitioner is to receive PCA amounting to 110,520. However, in terms of the subsequent letter dated 6/4/2015, the petitioner to be paid 99,60. This court had accordingly allowed the writ petition by directing the petitioner should be paid PCA at the rate of rupees 99,60. The review has been filed on the ground that the petitioner should have been paid the amount of rupees 110,520 per month in terms of the letter dated 5/6/2000. Next paragraph. The letter dated 25/4/2025 issued by the Assistant Administrative Officer, Officer in Charge, Regional Legal Cell, bracket Eastern Circle, HQ Additional DGBR, bracket East, is to the effect that the difference in BCA sanctioned by the above two letters was on account of deduction of two full servant components at the rate of rupees 5,456 per month. The said rupees 5,456 into no 5,646 when multiplied for two servants comes to 11. No, it comes to 10,91. Thus, the subsequent letter dated 6/4/2015 has not taken into account the two full service components payable under the RKB totally. Deputy SD can obtain his practice certificate. The petitioner was entitled to two full service components at the rate of 5,456 in terms of the BC. That's all. This is the matter. Let's pick whether the- When you are.
Just complement of two, I remember that is, if it is complement, it may be,
He shall also obtain instructions as to whether the complement of two service components it would be applicable to the petitioner. And as to whether the petitioner would require to have two service, two service for making a claim for the said amount of 10,91 during his Bhutan tenure.
It includes, because the page number is complete.
that is there. No, that is why I said both complement, that makes a lot of it.
Pusta. The, Pusta, also whether the petitioner would be entitled to the pay of the two service. Even if he did not employ two servants during his Bhutan time.
That makes.
The basis of the fifty allowance itself is 2001 order, which was upheld by a lordship. And that order itself says that the officer was getting that particular rate pay to that two full-time service.
Let us see, we do not know, I do not know, it is, you know, because you see, even as a judge, we are entitled to some pastoral time, bungalow pure. Now, if, and that is court, sometimes it is court service, sometimes different, it depends on different time. Now, the thing is that if you don't utilize a bungalow peon or whoever, you are entitled to that amount. That's again a different